In a criminal case, who actually decides what the accusation is? The Constitution answers that question. The grand jury defines the accusation. Once the grand jury defines the charge, the trial is supposed to test that accusation, not replace it. That means the charge in a criminal case comes from the grand jury, not the prosecutor and not the court. The trial then tests that accusation. Evidence is presented, witnesses testify, and the jury decides whether the charge has been proven. But the accusation itself is not supposed to change, because if the accusation changes, the trial is no longer testing the charge returned by the grand jury. It is testing something else. That is why courts have long recognized a rule. The charge returned by the grand jury cannot be replaced with a different theory during the trial. If that happens, the constitutional boundary has been crossed. In Jason Green's case, the grand jury returned an indictment for intentional murder. The entire trial was conducted on that accusation. But after the evidence closed, something unusual happened. The jury was instructed that it could convict on a different theory, a theory the grand jury never returned. That moment raises a simple constitutional question. If the accusation comes from the grand jury, who has the authority to change it?